Good afternoon to everybody and welcome to the Park Lane Plowden Law with Lunch. It is just after 12:30, so we will make a start, and I think as Megan has said, those people who join later can be allowed in. We're here today obviously to speak about a clinical negligence case law update under the Law with Lunch scheme that we do here at Park Lane Plowden. I think the last time we did this was myself and Abby Telford back in January of this year. So we've almost gone about 9 or 10 months before we've done a new update. Insofar as the cases that Megan and I have chosen, hopefully they'll be very much of use to you from a practical basis. And as you can see from the slides that's come up, those are the areas that we'll be covering in terms of a summary. And in respect of cases, I think we're going through 10 or so cases in relation to the subject areas mentioned. I'd just like to say before we make a start there that myself and Megan are conscious that two of the cases we haven't mentioned. One of those cases is Khan against Meadows, which is the Supreme Court decision with relation to scope of duty. And the other case that we're also aware of is the case of Thorley and Sandwell and West Birmingham Hospital NHS Trust, which is a very recent case dealing with material contribution. The reason that we decided not to deal with either of those today is that both of them almost deserve a lecture in their own right. What we can say in relation to that is that if anybody would like a lecture in their own right, please get in touch with us or the clerks and that can be arranged. Otherwise, what I would say in relation to them, certainly in relation to the first case of Khan and Meadows, there's an article that Leila Benyones from Chambers did in relation to that case, which is on the Chambers website, and also in relation to the second case of Thorley. There's a very recent article that Bharat Jangra, one of our pupils, has produced in relation to the material contribution case of Thorley. So we'd just like to bring those both to your attention before we move forward in relation to the cases that we're going to deal with today. I'll be going first, no more than the fact that the cases that I've done in terms of the slides are the ones that appear first, and not wishing to be ungentlemanly in relation to actually moving forward. So Megan, if we can actually just go to the first case, if we may, which is the case of Hughes and Ratton. This is a 2021 case which relates to dental negligence. Now, I would imagine that most of us have some dental negligence within the mainstay of our clinical negligence practices. This is a case that was decided by Heather Williams, Queen's Counsel, sitting as a Deputy High Court Judge. It's a very vital case from a practical perspective because in this case, the claim was actually brought against the defendant, who was the former owner of the dental practice for which the claimant had received dental treatment between 2009 and 2014. The defendant was a principal dentist in the practice and had been the owner for 28 years. He relinquished control in 2015. However, the case was brought as against him as the owner of the practice. Now, it's all important in relation to this type of case because the position is, as one would normally know in relation to dental cases like GP cases, one would actually go as against the individual dentist concerned, and therefore one can have the situation whereby there are a number of dentists who are sued on the claim form and the particulars of claim. The difficulty, of course, as we all know with that, is that you have difficulties in relation to sometimes finding the dentist concerned if they're still not in practice, the difficulty in relation to indemnity, and also, even if they're not indemnified, the difficulty that one has in relation to the fact that with dentists, it, of course, is a discretionary indemnification. The beauty of the claim, therefore, in relation to Hughes and Rattan is that it was a case that was brought simply as against the owner. And the position, therefore, if one was to succeed as against the owner on the basis of vicarious liability and a non-delegable duty of care, then a claim would succeed rather than having to go against each of the individual dentists concerned. So this is a matter, as I say, that came before Heather Williams, and it was on the preliminary issue simply in relation to whether or not a duty of care was owed by the owner of the practice by way of vicarious liability or non-delegable duty of care. In relation to the first aspect, the position was that there were 4 doctors whose treatment was criticised. The first of those, dentists was somebody who was a self-employed trainee dentist. And the position in relation to that was that there was no issue taken. In relation to the three other dentists concerned, there were three self-employed associate dentists, and the position in relation to that was that the practice owner said that he didn't actually or was not responsible for the treatment they provided. So as I say, the first aspect in relation to this is the question of vicarious liability. And in that respect, the question that the court had to consider was the relationship between the owner of the practice and the associate dentists sufficiently akin to employment? And if it was it just and fair, therefore, to actually presume a duty as against the owner of the practice? In relation to this, Heather Williams determined, yes, that there was a relationship between the owner of the practice and the associate dentist, which was sufficiently akin to that of employment. What she did in relation to that was go through a number of factors in relation to the question of control. And she decided in relation to certain aspects of that she determined that it was the defendant who determined when the practice was open. He actually set out the company policies and what was to be done and the training. And lastly, one of the other factors that she took into account was that in relation to any money that was paid over, 50% of the money is paid over to him as the owner of the practice. Now, one of the most important factors that was had regard to in relation to this was the matters that were considered in the Supreme Court decision of various claimants against Barclays Bank. A 2020 decision reported at UKSC 13. And in relation to that, the court determined in that position that if it was seen to be that the persons concerned were integral within the business itself, then that brought up a duty sufficiently akin to employment. In the context of this case, the judge determined that was indeed the case. She went on to say that in terms of the practice in this particular practice, that the defendant couldn't have carried on with the dental practice without the assistance that was being provided by the dentist concerned. And therefore, in relation to the first question, vicarious liability was found. The second duty, of course, was in relation to non-delegable duty. And in relation to this, the court had specific application of Lord Sumption's test set out in the case of Woodland Swimming Teaching Association, whereby he set out 5 factors that were to be considered. In the context of this particular case, the defendant admitted that only the first 3 factors were in dispute. Next slide, please, Megan. In relation to those factors, the judge found on the facts of these, the first 3 factors that were in dispute were indeed satisfied. She found in relation to the vulnerability of the claimant on the protection of the defendant to the risk of injury, that the claimant had gone to the defendant, she relied upon him in relation to the risk of injury that was concerned. The treatment was provided by the associate dentists, but in relation to all of this, the position was that he had an ability of control over the treatment that was provided. She was a patient of the practice, and she was not a patient of each of the associates. She also went on to say in relation to the this aspect of the case that the defendant kept all the records and made the appointments. In relation to the second of the duties in relation to this, was there an antecedent relationship between the claimant and the defendant, which placed the claimant in the defendant's care, entailing a positive duty to protect the claimant? That was answered also in the affirmative. Once again, reference was made to the fact of control in relation to appointments that could be made on behalf of the claimant, and also in relation to the fact that the defendant kept the record of the patient. Another matter that was also considered in relation to this by way of the control mechanism was the fact that the associate dentist also had to undertake training and selection by the defendant. So the second aspect was also found in the affirmative. The last one was in relation to whether or not the claimant had any control over how the defendant chose to perform the obligations, whether personally or through the employees or third parties. And in relation to this particular aspect, Heather Williams found that the position here was that whilst the claimant could say which of the dentists she would like to perform the treatment, it was within the remit of the defendant himself to say whether or not that treatment was indeed provided by that particular dentist or by another dentist, whether it be by way of a contractual relationship or in relation to an employee relationship. So taking all those factors into account, it was readily the position found by Heather Williams in relation to this case that there was a non-delegable duty of care in relation to the duty owed by the defendant. So she found in respect of both of these aspects that there was indeed a vicarious and non-delegable duty of care owed to the claimant. Now one can see that, as I've said previously, becomes important because one simply then has to sue the defendant in relation to any case of this type moving forward. It's also interesting to note that insofar as this decision was concerned, that it very much followed or mirrored the County Court judgments in two similar cases, that of Ramdian, which was decided in January 2020, which is of note to us because it was a decision of Her Honour Judge Belcher in the Leeds County Court, and also more recently in the case of Beckenbury, which was decided in the Cardiff County Court on the 19th of February 2021. Insofar as moving forward, I understand that the matter has indeed been appealed and that the appeal is now due to be heard by the Court of Appeal next year on the 13th of January 2022. So please keep an eye out in relation to that because of its practical importance in going forward in relation to who to sue in respect of these type of cases. Next slide, please, Megan. This is a decision of His Honour Judge Blair, Queen's Counsel, sitting again as a Deputy High Court Judge. It's an interesting case because it refers to spinal surgery, the evidence that's taken into account by a judge in deciding issues in a case, and lastly, the question of informed consent, and more importantly, to the specifics as to whether or not it was reasonable in the circumstances of this case not to provide any alternatives to the care that was ultimately decided by the treating clinician in this case. What happened in this case was that in July 2014, the claimant underwent MRI scans which established severe spinal cord compression at T10 and 11, and also cordoaquinal compression at L3, L4. The treating clinician concerned, Mr. Minus, performed emergency spinal surgery after an initial consultation. That operation was performed non-negligently, but unfortunately the claimant was left with neurological damage, which included numbness and weakness in the left leg. What then happened was that there were further scans that were undertaken, and the claimant went again to see Mr. Minus for further consultation on the 13th of July 2015, where again the scans were reviewed. At that consultation, Mr. Minus actually determined that surgery was needed at T10 to T11 and also at L3 and 4. Next slide, please. The second operation was undertaken on the 13th of August 2015, but unfortunately had very severe repercussions. The claimant was actually left with much more severe symptoms than he had previously. He was on complete paraparesis and was wheelchair bound for life and was classified as a paraplegic. The evidence that came before the court was in fact very much disputed. What the claimant said was that when he'd seen Mr. Minus in July 2015, so after the first surgery, the pain at that point had improved greatly and was simply confined to the lower back and the leg. He said, and this will become important as we move forward, that he wasn't asked anything about intercostal pain and that he had no risk of surgery explained and was unaware of the possibility that it could make matters worse. He also went on to say that there was no discussion of alternative treatments, and had he been told of any alternative treatments, that he would have declined surgery. The evidence that was given on behalf of the claimant was that there was an opportunity to have conservative treatment, whether by way of pain-killing medication or in relation to pain-killing injections. Minus, however, gave very contrasting evidence. He said that the claimant, when he came to see him in July 2015, had terrible pain from the left side of the back, with intercostal pain and sciatic pain down the leg and the foot. And he said that as a consequence of those complaints, he advised surgery to address the issues. And he accepted that without the intercostal pain, he would have simply played away to see game. Next slide, please. Mr. Minus readily accepted that he had not offered any surgical alternatives. And he said he did for these reasons. He did not do so for these reasons. He said that he deemed the claimant's condition to be too severe to be dealt with by way of nerve injections, and that they would have only had temporary effect. It was also seen to be the case as well that if you put him forward for those injections, then they would take him 6 months or so before he could have had them. And secondly, in relation to the analgesia, that had been tried before, and unfortunately it had no beneficial effect. He also went on to say, as to the risk of surgery, it explained that the risk would be lower than the first operation and that no spinal operation was without risk. He also said that he mentioned that there was a risk of paralysis in relation to the first surgery, and that would have moved forward in relation to this. In determining these matters, His Honour Judge Blair noted that there were inconsistencies in the claimant's oral and written evidence. He said that the pain mentioned before the second operation in 2015, lessening, was at odds with that which was set out in his statement. He also went on to say that in relation to the evidence that was provided by the clinician, Mr. Minus, he considered that to be impressive, cogent, and convincing. Next slide. As a consequence, he went on to find that the claimant had indeed complained of terrible intercostal pain in the July 2015 consultation, and having regard to the expert evidence, that he found that the responsible body of surgeons would have deemed the pain to be radicular, caused by compression of T10 nerve root, and that such body would have offered revision surgery in July 2015. So, quite simply, in relation to the question of Bolam, he found that in relation to this particular matter, the position in relation to this was that the surgeon had acted in accordance with the reasonable body of neurosurgeons. On the issue of specific consent, the judge went on to determine that Mr. Minus had given appropriate advice on risk, and that in the case, the alternatives were inappropriate and ineffective and hence not reasonable. Now, if we go back to that, of course, what was said in relation to the alternatives was that they could be in relation to the question of injections and in relation to pain-killing medication. The judge found that those would have been inappropriate because they hadn't worked previously and ineffective and therefore were not reasonable. Next slide. In relation to this, making an application of the legal side of this, the judge said this, that on the question of what was reasonable alternative treatment, he had to have regard to the other first instance decision of Bailey and George Eliot Hospital, which expressed the position that it had to be judged by what was known about the alternative treatment at the relevant time. Now, we know that that hadn't worked in relation to painkilling medication and also in relation to the question of injections. The judge then went on to say that he considered, therefore, that he had to look at the question as to whether or not alternative treatment should have been offered by reference to the prism of Bolam. And he said this, that I consider that the responsible, competent, respectable body of skilled spinal surgeons would have reasonably concluded that there were no reasonable alternative treatments available in the context of the parameters and discussion we had with Mr. Minus. Now, in that context, obviously, we have to take into account that the Montgomery decision in itself had set out that the duty was to take reasonable care to ensure that the patient was aware of the material risks in any recommended treatment and any reasonable alternative or variant. So in relation to this particular case, that second aspect of the reasonable alternative or variant was considered, and it was determined by the judge that there was no reasonable alternative that could be offered, and therefore informed consent itself was deemed to be appropriate in this case. Now, if one has regard to that, it's worth noting the decision in Duce and Worcestershire, the 2018 case, where Lord Justice Hamblin said in the Court of Appeal one of the matters that was to be considered was a twofold test. The first of those matters was what risks were or should have been known to the medical professional in question, and that was a question for the experts. So Bolam still applied in relation to that first limb. Now, in relation to this, one can actually add to that is in relation to not only the question of risks, but also in relation to the alternative treatment. So quite simply, Bolam was to be considered on that first limb, and in relation to the second limb as to whether or not the risks should have actually been referenced by whether or not they're material, that was a decision for the judge to make an assessment on. So if we can then move to the next slide. One of the other matters that was also mentioned in relation to this was that the judge expressed surprise at the practice adopted by the neurosurgeon in that he dictated a letter post the consultation setting out symptoms, clinical assessment, and other matters discussed, but had neglected to mention the risk and benefits of the options. He said it was a practice which was fraught with difficulty because these cases often fall to be determined upon the question of what was said or not said in relation to the question of risks and benefits. Lastly, he then went on to say that even if breach had been established, it would still have failed on the issue of causation, as he felt the claimant would have had further surgery in any event because he was in such pain that if he'd been presented with alternatives, he would have simply wanted to put an end to it by way of surgical treatment. And again, that was a matter that was considered in the Duce judgment, and also in relation to the case of Diamond at Devon County Council, where it was clearly established that even if one was to actually establish breach of duty for informed consent, the causation itself also had to be established. The next slide, please, Megan. The next case I want to turn to is a very interesting case of Robinson and Mercia. This is a case that was determined at first instance on the 9th of September of this year. It was a claim that was brought, again, in dental negligence, but it was actually relating to treatment that was provided by the maxillofacial surgeon at the defendant trust. What had happened in this case is that the maxillofacial surgeon had allegedly, according to the claimant, failed to remove an upper molar, whilst at the same time as removing two lower molars under general anaesthetic. Now, this case was a case whereby the claimant had actually brought evidence from a Dr. Mercia, who was a general dental practitioner, who hadn't sought to bring evidence to show negligence from a maxillofacial surgeon. And in relation to all of that, unfortunately, the difficulties arose almost immediately. In relation to this case, a matter came before the recorder at Liverpool County Court. And during the course of the trial, Dr. Mercia, the general dental practitioner, admitted under cross-examination he never worked in a hospital setting other than to observe another practitioner on only a few occasions, that he had no experience in surgical removal of teeth since 2000, and he also very readily accepted that the defendant's expert maxillofacial surgeon was better placed to opine of the standards to be applied to a maxillofacial surgeon. So we can see in relation to the evidence that came out in trial, it wasn't good for the claimant. Next slide, please. And it wasn't so good to the point that the claimant decided to discontinue their action at the conclusion of the evidence. And what happened was immediately after the trial, the defendant applied for a third-party cost order in the sum of some £52,000 and odd in relation to the costs that it incurred since the start of proceedings, and which it said would have been avoided but for the conduct of Dr. Mercia. At the conclusion of the trial, the defendant, having sought 21 days to consider the application of the wasted costs order, the judge in the application that was subsequently made for the third-party costs order went on to say this, that Dr. Mercia blanked his screen at that stage in the proceedings, and unbeknownst to the court, wasn't even listening to this part of the proceedings about whether or not the third-party costs order should be applied, because he'd gone to pick up his son from school. So all of this just simply came to his attention at a much later date. Next slide, please. Now, in relation to the question of bringing a third-party costs order as against a non-party to an action, the court, in considering the actual application, said that obviously under Section 51 of the Senior Courts Act, the position was that the court had of the Supreme Court Act, that should read, the court had the power to order a party's legal or other representative to meet all or part of any wasted costs. In doing so, though, a three-stage test had to be applied under the case of Ridhal. Firstly, the representative of whom the complaint was made had to act improperly, unreasonably, or negligently, and if so, did such conduct cause the applicant to incur unnecessary costs? And lastly, if so, was it in all the circumstances just to order the representative to compensate the applicant for whole or part of the relevant costs? In determining that, if we can then move to the next slide, please, the judge had regard to a number of cases. The first was Fitz and Symes, where it was decided that an expert witness who causes significant expense to be incurred by his evidence in flagrant reckless disregard to duties to the court under CPR 35 could be added as a party to enable an application for a wasted costs order, which was what was applied here. But it then went on to say that it was exceptional to make such an order against a non-party, and therefore the determining question was whether in all the circumstances it was indeed just to make the order. And lastly, in consideration of this particular case, it said that once the expert breach is established, the defendant has to establish that there is a causative link between the particular conduct of the non-party relied upon and the incurring of the costs sought to be recovered under the Section 51 jurisdiction. The next slide, please. The judge went on to consider the application for the wasted costs, and in doing so levelled what can only be said to be a whole series of criticisms against Dr. Mercia. And at the end of all of that said this, that it should have been obvious to Dr. Mercia at the outset and at various stages throughout the proceedings that he was not the appropriate expert to opine on the management and the treatment afforded to the claimant. So all in all, the judge concluded that in relation to the third-party cost order that was brought, that indeed there had been a flagrant and reckless disregard for the duties owed to the court, in that he'd prepared a report on subject matter upon which he had no expertise, that he'd done so without such conduct that no claim would have been brought, and lastly, the defendant would not have incurred the costs within its cost budget. So having regard to all of the factors, the court determined that a wasted costs order could be made as all the criteria was met. The judge finished with this stinging rebuke that a public body had been put to considerable expense in financing costly litigation that should not have been brought. Next slide. Now, many may be able to remember that this is not only the only decision in relation to third-party cost orders that have succeeded rather recently. There was also the other decision in the case of Timaya in Lancashire, which was also a Northwest case, where His Honour Judge Evans, in that unfortunate matter, made a third-party cost order as against the spinal surgeon concerned in the sum of just over £88,000. That was a slightly different case in that in relation to that one, the claimant's expert unfortunately had been able to actually translate the test of breach of duty in clinical negligence cases. And again, in relation to that, what happened is that the claimant had to discontinue. Now, one can look at both of these cases, both brought by defendant NHS trusts, and see that in respect to both of them, they've been able to navigate the maze of one-way cost shifting in order to recover costs that they would not otherwise have been entitled to under the provisions of the one-way costs system. The difficulty in relation to that is that one would then consider, is this a practice that's going to be used by the defendant trusts moving forward? I think the reality in relation to this is that, unfortunately, there's two cases which have come recently close in time to each other, whereby the experts, unfortunately, have made these mistakes and not complied with their duties, and that it has enabled the defendant trusts to be able to make the applications. However, I don't think it's going to become the norm. It's simply something that was actually allowable under the particular circumstances of these cases. Last one, thank you. The last case I just want to consider is the case of Negus Guy in St. Thomas's, and it's a decision of Mrs. Justice Eadie. It relates to the subject of valve replacement surgery undertaken in March 2014. I want to confine it to relatively narrow issues. Here was a position where the judge found that there was no basis for her to conclude that there had been a breach of duty. But what she went on to consider what was actually said in relation to the cardiothoracic surgery expert evidence that was presented, in particular that evidence that was presented in the context of the Bolam and Blythe principles. She went on to say this in relation to the expert evidence, that she admitted that each of the cardiothoracic experts were acknowledged experts who'd enjoyed considerable success in their careers, and that they were indeed to be afforded due respect, and both held themselves out to very high standards. She went on to say this, though, that at times this was a characteristic that was unhelpful in this case, leading the expert witnesses to lose sight of the test to be applied in these proceedings. Next slide. She referred to the fact in relation to one of the experts on behalf of the defendant that at paragraph 1 of his report, he spoke of one of the procedures now being relegated to history books, the view which she went on to say she didn't find shared by all reasonable bodies of opinion. She said that the procedure concerned may be a relative rarity, and there may be competing views as to the risks and benefits of the procedure. But she went on to say that she didn't find it to be characterized as relegated to the history books. And also then applying it in relation to the claimant's expert, she commented that in cross-examination, that it was demonstrated to be based upon a particular opinion as to how things should be done, that the claimant's expert had expressed his opinion, rather than allowing for possible alternative views that might still be recognised as proper by a competent, reasonable body of opinion. She went on to say that the concern in this case is that so many of the allegations against Mr. A, who was the clinician concerned, appear to have been based upon the application of the wrong test. So what Mrs. Justice Eady was having regard to was that there has to be note had as to whether or not the expert is applying the Bolam-Blythe test. And as practitioners moving forward, I think it's very noteworthy that we should have regard to the specifics of that in relation to the breach of duty report and in relation to any conferences that may be had in order to make sure that that test is being applied. And if I can simply finish by her final comment in relation to this on the next slide, she spelled out the following: that whilst respect is to be afforded to the views of the experts in particular fields, the determination of breach of duty and clinical negligence remains firmly a matter for the court. Negligence will only be established if the treatment undertaken is outside the range of professional opinion, but that is the subject to the court being satisfied that the views within that range are capable of withstanding logical analysis. So very clearly setting out the Bolam and Blythe tests. Those are the cases that I simply want to go through. I think if I can now just hand over to Megan.
Thank you, Jonathan. Could you give me a thumbs up on your screen that you can hear me okay? Thank you. So I've got 5 cases on the slides, but I won't be going through all 5 in detail. They're part of 3 groups. The first one is about non-delegable duties. There are 2 about fundamental dishonesty and 2 about secondary victim cases. So the first one is Hopkins and Akrami, and this is a recent case, but decided upon relatively historic negligence. So it's negligence from 2008. The reason I have included it is, of course, it's a recent case, but it's a helpful reminder to be considered in conjunction with the case that Jonathan was referring to earlier about non-delegable duties and whether we consider them under the common law test or whether it's in fact a bit more simple than that. And so in the case of Hopkins, out of hours primary medical services were provided to NHS patients via a contract between the defendant and the NHS trust. The child in this case was given antibiotics, and subsequently 2 days later a brain scan revealed hydrocephalus. So she had fluid on her brain, and sadly she suffered permanent neurological damage. The issue was whether the trust owed a non-delegable duty of care to the child who was an NHS patient, because there were 3 defendants. The first was a nurse practitioner, the second was the defendant company who contracted with the trust, and then the third was the trust. So it was a preliminary issue between the trust and the claimant as to whether they ought to be a defendant or not. The statutory duty in play, which is very similar to the statutory duty now, was to provide or secure the provision of medical services in the trust area, and that includes contractual arrangements. And so this is the difference between this case of Hopkins and the case Jonathan was talking about, because this issue was decided by assessment of the statutory regime, not common law. So the judge did not need to consider Woodland and did not need to consider the multiple stage test. And it was only where the statute was silent on delegability that Woodland would come into play. And so in this case, the judge said the duty was either or. So either the trust would perform the services or the trust would arrange the services. I've put on the slide section 83, which was the relevant wording at the time. It's slightly different now because rather than talking about primary care trusts, it talks about health boards. But the duty is still the same in that it's either to provide or secure. And subsection 2 is very similar now as it was in 2008, in that it specifically says a trust can make contractual arrangements with any person for the provision of the services. And so the judge said, look, this is incredibly sad. The first defendant practitioner does not hold adequate insurance to pay for the child's damages. She was very severely disabled and required a lot of care. The second defendant was uninsured for these purposes, so did not hold adequate insurance, despite the fact that it ought to have done. And so the trust wasn't a defendant because it didn't owe a non-delegable duty of care. So though it was very sad, the interpretation of the statute was pretty clear for this claimant. And the judge said an analogy might be the claimant sues a GP surgery and they hold inadequate insurance. Just because the insurance isn't there doesn't mean we can find another defendant if there isn't a statutory or common law reason to find that they hold a duty. So that's the relevance of this case. And I thought it quite nice to tie in with what Jonathan was talking about. The second case is Idon and Warner. This is a fundamental dishonesty case. The reason I have chosen to speak about these two, this one and the next, is of course they're recent cases, and this is a case law update, but also quite interesting because it's very easy, I think, for us to consider that we might escape the perils of fundamental dishonesty and clinical negligence, and that's the stuff of personal injury claims. But unfortunately, that's not right, and we must always have our wits about us for it. It undermines everything that we do as lawyers, whether we are claimant or defendant lawyers. And so this case of Idon is quite interesting. It's a misdiagnosis of breast cancer case. Breach of duty was admitted, so it was causation and quantum in dispute, relatively straightforward. The misdiagnosis meant that the claimant had to undergo mastectomy, axillary dissection, and chemotherapy, hormone therapy, and radiotherapy. So it was all pretty nasty for this claimant. And so she had a valid claim. But her case was all of these therapies and treatments meant that I now suffer debilitating chronic pain, such that I am severely disabled. I cannot walk without assistance. I need a phenomenal amount of care from my husband, and the claim was pretty big. Previous to her injuries, she was an open water swimmer and a very active person. And so it's probably not surprising that in a chronic pain case, with a formerly very active person, the defendant commenced some surveillance, which lo and behold, showed the claimant was participating in sporting events, 10K runs, Great North Swim. There was a variety listed in the judgment. Then what happened next, retrospectively, might be considered a little bit silly, because the claimant doubled down on everything. So after the statement with the surveillance was served, the claimant served another witness statement saying, no, I'm severely disabled by chronic pain. She then amended her particulars of claim to advance her case, that she suffered this chronic pain, she had numbness, and she was severely disabled with fatigue and psychological injury. She then, in the course of litigation, recruited her husband and another witness to provide false statements about these sporting events that she was attending, and served another statement herself, denying participating in 3 open water swims. She said, later in 2020, I've given you full disclosure of all my sporting activities. She even says, look, I told you I was taking hemp oil for pain. I didn't quite tell you I was taking cannabis for pain because I was worried, but you know, I still was doing all of those things, and I really am in chronic pain. And then it went to court, and then she continued to advance this case of chronic pain in the witness box. And so it's not really surprising that on the balancing analysis of the surveillance, the judge said the claimant is dishonest. And so the defendant made an application under Section 57. Section 57 being the relevant application because there was an honest part to the claim, but there was fundamental dishonesty in relation to the primary claim. So the distinction being a dishonest claimant versus a dishonest claim. And so the court must dismiss the primary claim unless it is satisfied that the claimant would suffer substantial injustice if the claim were dismissed. So there was still an opportunity for her to recover some damages if she could prove substantial injustice. And I have to say, when you read the judgment, it's not surprising that the judge said no. Substantial injustice is quite the test, and she doesn't pass it. The judge said that the claimant's dishonesty amply justifies the adjective fundamental. Firstly, her dishonesty did not go to some incidental or collateral part of the claim, it went to the heart of the claim. Secondly, her dishonesty has substantially affected the presentation of her case. Indeed, it has pervaded her case to the extent that she has scarcely taken any step in the action that was not tainted by dishonesty. And thirdly, the effect of her lies was to inflate the value of the case from £70,000, which the judge held she would have been awarded, to over £900,000. And so on that basis, she was fundamentally dishonest. The claimant says, well, hang on, we've had an interim payment and I've bought a house, and that's substantial injustice, that I now own a house, and what am I supposed to do? And the judge said, Parliament has plainly concluded that the aim of addressing the evils of dishonest claims justifies depriving a claimant of part of the claim he can prove, and providing the defendant with the windfall of not having to satisfy a lawful claim, albeit one that may have been dishonestly presented. I don't think that the claimant suffers substantial injustice merely because the defendant is not required to pay damages, and because the claimant does not have funds to seek therapy she wants. These are inevitable corollaries of the operation of the statute. And the position of her buying a house, it is not substantial injustice. There is a means within the rules for the court to order that interim payments are returned. So that in and of itself is not enough. So her claim was dismissed and she took away nothing. The next one is Calderdale and Huddersfield NHS Trust and Metcalfe, a little more sizable than the £900,000 we were talking about in the case of Idon. And this was a Cauda Equina case, notoriously unpleasant cases for claimants, and liability was admitted in this case. It was just quantum in dispute. So a similar theme potentially to the Idon case, that breach of duty was not an issue. So it seems relatively straightforward. And again, the defendant obtained surveillance that showed the claimant had exaggerated her physical disabilities. The schedule of loss was grossly exaggerated at 5.7 million, and her legitimate claim was about £350,000. Now, you'll see the next bullet point says that the claimant admitted lying, and she agreed her claim should be dismissed for dishonesty, and she agreed to repay the interim payment. So the reason I've included this case is because the defendant made an application for contempt of court. I think this is probably helpful to have in our minds when advising claimants for fundamental dishonesty, and as defendants when considering to make a contempt application. It's a pretty helpful judgment that sets out the considerations for whether someone will be found in contempt, and if so, what the sentence may be. As PI civil lawyers, it's not something that we dabble in very often. You know, the concept of sentencing can be a little bit daunting, but it's a good little judgment. And so had these were some of the factors that the judge considered. Had the dishonesty not been discovered, the claimant would have extracted millions of pounds from the NHS. It was a conduct that had been pursued over a number of years. There were a number of contempts, and the volume when the quantum claimed was very large. However, there was a genuine claim. Liability had been admitted, and this claimant was in very poor health. She had no previous convictions, had admitted lying, had a young daughter, and in particular, the court commented on the impact of the pandemic on prisons, and that any prison sentence was in fact probably a bit worse as a result of the pandemic. And so the starting point for the sentencing would have been 18 months. That was reduced to 9 on account of her mitigating features, and reduced to 6 because of her admissions and acceptance that she had lied and was in contempt. And the court said that the appropriate punishment for faking evidence in support of a claim inflated by £5 million could only be achieved by immediate custody. A suspended sentence would not be appropriate. So some helpful comments there if we are in a position to advise a client saying, well, what happens to me now? Something to be considered there. And then the last 2 cases from me are about secondary victims. This first one, probably a little bit more exciting. It's Polmere and Royal Cornwall Hospitals. And there's an appeal outstanding with permission given to appeal directly to the Court of Appeal. P was a little girl. She was about 6 years old, and she had been referred to the hospital by her GP with history of episodes with shortness of breath, rapid breathing, fast pulse, and some generally unpleasant symptoms which her parents were naturally quite worried about. There was an investigation, continuous CTG, and in that 24-hour period there were no episodes that P suffered. And so the clinician said P symptoms are probably best interpreted as exertion and as physiological symptoms. She continued to suffer these episodes of increased frequency and including vomiting, and so a second opinion was requested by her GP. Sadly, before that second opinion was obtained, P collapsed in July 15, and despite resuscitation attempts, she died at 6 years old. Her condition was pulmonary veno-occlusive disease, and it should have been diagnosed and treated in January 15. That was admitted by the hospital. The claim, of course, was for the secondary victims, her parents, having witnessed the collapse and death of their daughter. And the defendant hospital made an application to strike out because the point of negligence was 2015 January, and the point of death was 2015 July, some 6 months later, which did not satisfy the proximity control mechanism in relation to secondary victims. The issue then was about the point of negligence and the event. The claimant said that the failure to diagnose became manifest and evident in July at the point when P collapsed. That was because although the breach occurred in the January, and although she continued to suffer symptoms of these episodes, they didn't know at that point that there had been a breach. And though her conditions were as a result of that, that didn't preclude them bringing a secondary victim claim, because the event, so the shocking event for the secondary victim claim, hadn't yet occurred. And the claimant relied on the case of Paul. But in the case of Paul, an appeal was outstanding. The claimant said, look, it's binding. There's been a first instance appeal. Defendant said, no, it's not. There's a further appeal outstanding. And the court followed Paul, because the High Court had overturned the very same master's decision who was deciding this case of Palmer, and said, just because there's an appeal outstanding doesn't mean I can't decide the case. Nobody asked me to stay this claim for the outcome of Paul, so I'll rely upon it. And so the decision was there was actionable damage between January and July, but it was helpful to stand back and reframe the argument on the basis of the unchallenged evidence. And the court said this: a hospital trust negligently fails to diagnose a life-threatening condition in a child. The child continues to experience the consequences of that life-threatening condition beyond the point at which it should have been diagnosed and treated. The parents are not unnaturally concerned at the child's condition and seek further medical referral. Shortly thereafter, the child has a more serious episode, as a result of which she dies. In the course of that final episode, the parents are present, involved in the attempts to resuscitate their child, and suffer psychiatric injury as a consequence. One might consider that the language used is quite emotive, although not in dispute, that this was a very sad case of a little girl dying. But the judge said that's what we're dealing with. And so the question is, why should the fact that the claimant has suffered non-fatal episodes on previous occasions rule out the secondary victim claim? On what basis does that mean these parents cannot pursue their claim? Now, her final episode could appropriately be described as a fact and consequence of the negligence. It was possible to identify it as a qualifying shocking event, and so it was not necessary to identify a stopping point. So the stopping point at which the parents could no longer claim as secondary victims. And that's because of the factual background. The shocking event did not have to coincide with or immediately precede the first actionable damage to the primary victim. And so that actionable damage between January and July, being the continued episodes of shortness of breath, was not a bar to recovery, and the claim was not bound to fail, so it was not struck out. It's really quite interesting because it's quite a short period of time, and the court has seen other cases involving longer periods of time between the negligence and the point that the secondary victim event arises. Most often with no symptoms at all between, and in this case with some very minor symptoms, but with no link yet to the breach of duty until July. So it's worth looking out for when that appeal comes. Paul is going to the Court of Appeal as well. I'm afraid I don't know when they're due to be heard, but no doubt we'll do another talk on it and keep you all updated. And so in the final few minutes, I just want to flag up this case of King, also a secondary victim case, and it's a neonatal death. The father sought secondary victim damages. The baby was born in distress, and transferred to the intensive care unit. On the father's first visit to the NICU unit, he asked, "Is P still alive?" And that's because the baby was not in distress. The only indication was the wires and the machinery. Baby was very still and very calm, so no twitching and no discoloration that would imply distress. And the doctor's response was, yes, he's still alive, but he's very sick and we might lose him. And P died 5 days later. The hospital admitted liability, and so the claim, admitted liability for the death, I should say, and the claim was about PTSD caused by the psychological impact of seeing his critically ill son on the first visit to the NICU after birth. Now, it's probably worth a little reminder that the 4 control mechanisms are a close tie of love and affection. The claimant must have been close to the incident in time and space. Claimant must have directly perceived the incident rather than hearing about it in third person. And the event must have been sudden and shocking. In Alcock, that was described as a sudden and unexpected shock, which amounted to a horrifying event which violently agitates the mind. The judge said this: the father was fully prepared for the machinery and interventions. He had been warned that his child was very sick. The baby was peaceful, no sign of distress, and there was no panic upon the visit to the intensive care unit. And so the judge said, in ordinary language, what happened to the claimant was horrifying. He'd been waiting the birth of his second child. It should have been a joyous event, and instead he was told that P was seriously unwell and might die. But this was not an objectively shocking and horrifying event in the Alcock sense. And that's because of considerations which are summarised in the judgment, that this claimant was forewarned, though in the wider context preceding the birth, this is not an event he was expecting. He knew that the baby was unwell. The doctor had been candid and considered it was an honest response to explain to the father that P might pass away. And this was in a hospital setting. So though it's always horrifying when we lose loved ones, this is not such a shocking and horrifying event in the Alcock sense. And really, the judge said these types of cases should be determined on a case-by-case basis. So it's another helpful one to bear in mind when we're considering secondary victim claims. Some say secondary victim claims are indeed secondary cases. They're not given the same type of weight and priority as primary victims. And that's probably right in the sense that we have the criteria set out to be established. And it's certainly emotive and upsetting that the father couldn't recover damages in this case, but there needs to be something more for a secondary victim claim to succeed, and that's what King reminds us of. So that's it from me. The time is 1:30 on the dot, so we've talked at you for a little while, but I think, Jonathan, we've got some time for questions if there are any. I can see the chat and the Q&A box, and if anybody needs to dash off or doesn't have anything for us now, our email addresses are on screen.
Thank you very much there, Megan. Yes, if anybody would like to ask any questions, feel free to do so by speaking up, or as Megan has said, in relation to addressing the questions to the question and answer button. No, it seems nothing in either regard. We've obviously spoken to you at length in relation to this, and obviously you're either satisfied or have other things to do with the rest of your day. Thank you very much in relation to taking the time to listen to myself and Megan talk about today. And as I say at the outset, I hope we've actually covered matters which are of practical use to you in relation to your practices. I'd re-emphasise what Megan has also said, that if you've got any further questions in relation to anything that we've talked about today, please feel free to get in touch with either myself or Megan to discuss those. And again, as I said at the very outset of this talk, if there are any other cases that you think you would like to hear anything about, please get in touch with either of us or indeed the clerks to discuss those. Thank you very much.
Thank you, everybody.